Buenas tardes a todos. Nos encontramos hoy dentro de la semana del Departamento de Derecho Económico, acompañados por los profesores Kevin, Tobia y Eric Martínez. Kevin es profesor de la Facultad de Derecho de la Universidad de Georgetown y Eric es investigador doctoral actual en MIT. Quiero ya empezar nuestro evento en inglés. I want to thank both Kevin and Eric for joining us. This is the week of Law and Economics at the Law School at Javeriana University here in Bogota. Let me present the schedule, the plan we have for today's academic event, and a little bit about our team, our academic team. So basically, we have your presentation for half an hour, roughly between 2:10 and 2:40. Kevin and Eric will speak about a very important topic, which is what is the meaning, what is the general perception across law schools in the United States about the law and academia. Then I will comment about their article for about 10 minutes. Around 2:50, we'll begin a dialogue based on some questions that the academic community have about this important topic. And in the end, roughly between 3:15, 3:30, 3:40, there will be questions from the public. We will try to channel those questions via the chat section of YouTube. So Kevin and Eric, let me basically talk a little bit about our team. Dean Botero just took office back in March of this year. He is SJD from Georgetown. He has received an LLM from Harvard, and he's a lawyer from Universidad de los Andes, which is one of the leading universities in Colombia. He was the executive director of an institution called the World Justice Project. And he also was an associate researcher at Yale and a consultant at the World Bank. He's our current dean. Our team is led by Professor Uribe. Professor Uribe is the mind behind this week. And along with Professor Uribe, we are a team basically of 8, between 7 and 8 professors, full-time professors. Each one of us at the Departamento de Derecho Económico teaches and researches areas related to law and economics, international law, philosophy of law, etc. Let me introduce Kevin and Eric to the audience. Kevin is an associate professor of law. He basically conducts research on legal theory, empirical legal studies, legislation, health law, LGBTQ law. Kevin received a BA, summa cum laude, Phi Beta Kappa in philosophy, mathematics, and cognitive science from Rutgers University, an MA with distinction from Oxford, and a JD and a PhD with distinction from Yale. One of the, in my opinion, most impressive things about Kevin's CV is that apart from all these degrees, he was the articles editor of the Yale Law Journal and also the editor in chief of the Yale Journal of Law and the Humanities. So it's very impressive. I want to thank Kevin for his time, for his kindness, and for your time. And Eric also has a very impressive CV. Eric holds a JD from Harvard. he has been admitted to practice in Massachusetts, and currently he's a PhD student in cognitive science at MIT. One of the things that I found very interesting in terms of what Eric has done is this that I found. MIT News, this piece talks about, correct me if I'm wrong, Eric, some of your opinions about legal writing, which is something that I guess not only in the US, but across different latitudes, we are always worried about. So perhaps ahead we can discuss about this. Thank you very much. Let me give the floor to both Eric and Kevin, so you can start. I will stop sharing the screen and go ahead. Thank you very much.
Well, thank you so much for your time and for inviting us. It's a pleasure to be here discussing this paper with you, and then our broader conversation about law and legal education. So we have some PowerPoint slides which I'll share. And so the plan for our brief presentation here is I'll say a little bit about the background to this project that we have, kind of why we decided to run a study surveying law professors about their beliefs about law, legal theory, and the academy. And then I'll turn it over to Eric, who's the first and lead author on this paper, to go through a lot of the nitty-gritty about what we did in the study and what we found. And he'll say a word about some limitations. And then I'll come back at the end and kind of open up a little bit more broadly a discussion, some questions about future directions and questions that the study raises. So that's the plan. Sort of why do we do this study, what the study is, and then some limitations, implications of future questions. The first, why do we think to do this? There's a few different reasons that we decided to survey law professors about their beliefs about law and the legal academy. So one, to say also at the outset, our study is inevitably extremely American focused. And so I think this is also one of the questions we can come to at the end is, what might this sort of study look like in other countries or jurisdictions? But in the US, these sort of statements have had a lot of purchase recently. So this is Supreme Court Justice, US Supreme Court Justice Elena Kagan, who famously said, we're all textualists now and we are all originalists now. She's recently clarified both statements, sort of in some way qualifying them. But these sort of statements, this is just an example, right? We're all originalists now. Some legal scholars say we're all realists now, or we're all purposivists now. And so, one question we had about these statements is, to what extent, I mean, maybe they are hyperbole, but insofar as they're gesturing towards some sort of shared belief among a large number of members of the legal academy or the legal profession, which of these are statements is accurate. So these are these kind of universal claims. We're all originalists, all textualists. There are also claims about the unpopularity of some views. Formalism is dead. Prison abolition is not a sort of popular view. So these sort of statements, right, appear in the literature. And so one question we had just at the outset is, let's try to get a little bit of insight into which of these claims is true and what level of support there is within law professors about various theoretical views. More broadly, right, a lot of what we do as law professors is write these articles in law reviews or peer-reviewed journals, and typically these articles include arguments, often for or against different legal theories. Here are some reasons why you should be an originalist or a living constitutionalist. And so you could also wonder, these debates, some of these debates have gone on for decades or longer, and so another motivation for the project is let's just sort of take stock and see, there's not going to be a perfect measure, but just as a sort of reference point, looking at which views law professors endorse gives us a sense of which views have proven persuasive today and which, at least comparatively, more or less persuasive. I think a third motivation is we're very much indebted to this project from philosophy, sort of wonderful project from two Davids, David Bourget and David Chalmers, who ran this study a bit earlier in 2014 about what philosophers believe. So they their idea was, we want to know, there are all these philosophical debates about morality and knowledge, and let's survey philosophers and get a sense of whether there's consensus or not about many of these questions. And so, this was a big launch point for us. We were very much inspired by this project, and you think of the legal theory part as a disciplinary spin-off of this, and you could imagine similar projects in other disciplines, or even with respect to other legal jurisdictions, so theoretical debates outside of the US or in other countries. Turning to the legal education part of the study, so we asked these questions about different legal theories, but we also asked questions about how central different areas of law are to the legal academy. And so legal academy, we're construing pretty broadly to include legal scholarship, research, teaching. So these kind of conversations, right? Which areas are more or less central? Which areas should be central, say in the curriculum, right? Those kind of conversations happen pretty regularly. And there's a lot of anecdotal evidence about this, right? People say, well, our students really need to know more about legislation and statutory interpretation. We really ought to require students to take that class, or this class or this subject matter was really relevant in 100 years ago, and it's sort of less relevant in legal practice today. Maybe we need to de-emphasize it. And here too, right? Our goal was to contribute to those debates just with some data and try to get a sense, surveying a broader population of American law professors. Are there trends? And if not consensus, in which areas are understood to be relatively more central or less central to the legal academy? So that's a sort of descriptive question. But then we also asked which areas should be more or less central. And pairing those kind of two questions also gives us some interesting results. So just to kind of wrap up the motivational slide, right, why are we doing this? One, this Felix Frankfurter quote, another former judge in the United States, is sort of helpful for us. So he says, law is what the lawyers are, and lawyers are what the law schools make them. I feel a bit arrogant adding this as a law professor, but we say, right, law schools are in large part what the law professors make them. And so I want to emphasize, right, this is not the only story. So I think with all of these, we would kind of qualify them. Law is in part what the lawyers are, and lawyers are in part what law schools make them, and law schools are in part what law professors make them. But if you sort of think about this line, right, if we want to learn something about the law, it's sort of sensible to look to lawyers and what they're doing as some descriptive evidence of what the law is. And they start in law school, right? That's the origin of their legal training, and then they get a bunch of experience afterwards. And so looking at what's happening in the law school doesn't tell us everything, but it will give us, we think, some insight into what lawyers are and become, and then even maybe what the law is. So kind of zooming out, more big picture, that's the main motivation for this survey. But now let's get into it. What do we actually do? I'll turn it over to Eric.
Yeah, thanks so much, Kevin. And also, yeah, thanks so much again to Andrés and to Javeriana and the rest of the team for hosting us. I guess one quick thing is just before I begin, while I was in law school, I spent a summer actually in Bogota at the Attorney General's office. And while I was there, I had the pleasure of interacting with several lawyers from Javeriana and just had an overall really wonderful experience. So I'm especially excited to be here and hear your thoughts on the project. But anyway, yeah, so I'll turn now to describing how we went about collecting the data, as well as kind of give a brief snapshot of some of the more interesting results we found. And so in terms of our participant sample, we were interested in the beliefs of law professors. So we recruited law professors in 3 different stages. So first, we emailed professors from the top 20 United States law schools. That was about 1,700 people, and then 294 of those people responded. And then we emailed professors from the rest of the top 50 United States law schools. That was about 1,500 people, and 261 of those professors responded. And then finally, we just created an open link. The first 2 lists were kind of just sort of pragmatically, we just needed a bunch of law professors, but ultimately wanted to get data from United States law professors at large. So we just had an open link where people could take the survey, and then of those people, 112 of those were self-identified law professors, and those are who we decided to analyze according to our pre-registration plan. And in terms of the content of the survey, we had two parts. In the first part, we asked professors to evaluate how central different areas of law they perceive to be to the academy. And so, as Kevin mentioned, this type of format was inspired by similar work in philosophy. So this part in particular was, inspired by work by John Turi, where professional philosophers were asked to describe how central they thought different areas of philosophy were to philosophy. And so our work was similar to Turi's work, but with a couple deviations. So here's an example of one of the questions for this part. In this case, a professor would be asked about comparative law, and they would be asked to rate on a scale from 0 to 10 how much they thought this area was central to the legal academy, as well as how much they agree that this area should be central to the legal academy. And so that way we can kind of get two measures there. And so obviously comparative law is just one area of law. We had over 100 areas of law that we asked about. Each professor saw a subset of 25 of those different areas. This included about 17 areas that are generally considered pretty central, such as contract, property, criminal law, and so forth, as well as about 8 random areas from the remainder of the set. And for each area, we analyzed both descriptive and normative centrality, as well as the centrality gap of that area. In other words, on average, the difference between how central a given area is compared to how central that area should be. And so, just to give a sense of the results visually, here's a graph of the centrality gap by area. So on the x-axis is just the average, centrality gap of a given area. So in other words, how central is a given area relative to how central, professors believe that area should be. And so on the y-axis is different areas of law. So, areas at the top are areas that law professors believe should be more central than they already are. And the top 4 such areas were legislation, legal drafting, property law, and local government law. And this graph actually only shows the top half of areas that the law professors believe are the most, most under central. And so, on the next one is this bottom half of the same graph. And at the bottom of the graph, you can see that the areas that law professors believe, are more central relative to what they think that they should be. And this includes areas like federal courts, appellate practice, constitutional law, and law and economics. And those are just kind of a few handful of areas that law professors in our sample thought were over central. And one other thing you can kind of get a sense of from this graph is that most areas are actually seen as under central to the academy. There's more bars to the left and to the right. But at the same time, it's also the case that law professors as a whole didn't necessarily believe that most of these areas should be central to the academy, just that they should be more central than they currently are under the current system, which you can kind of get a sense of from other graphs in the paper, and if anyone's interested, I'm happy to talk about that. But yeah, that's a bit of what we did in the legal the centrality part. In part 2, we were interested in gathering data about law professors' beliefs about different legal theory issues such as constitutional interpretation, prison reform, capital punishment, and so on. And again, as Kevin mentioned, we're indebted to the two Davids, David Berger and Chalmers. And we followed the format that they used in their study with, again, just a couple of deviations given disciplinary differences. And so this is a sample question from this part. And for a given question, we presented participants with a given legal theory debate, such as, what theory should judges apply when interpreting the US Constitution? And for each of these questions, we presented participants with a set of theories. So in this case, originalism, living constitutionalism, pluralism, and common law constitutionalism. And for each of those theories, we presented participants with a set of 4 possible main answers. So reject, lean against, lean towards, and accept. And in case participants found any of those 4 main answer choices unacceptable, we also presented participants with 5 other answer choices, which included no fact of the matter, it depends, question unclear, insufficient knowledge, or other. And this was obviously just one question. We had 25 such questions, each of which were presented to all participants. We kind of settled on this list after a bunch of iterations of drafting and talking to a bunch of different law professors for feedback. And in the final list, we tried to include a wide range of questions that we thought were important and might be interesting to a broad range of participants. But obviously there's some stuff that gets left out. We talk about this to some degree in the paper, but if we'd also be happy to talk about it offline or afterwards. So yeah, those are the kind of the questions. In terms of the results, we'll just highlight a few here that we kind of found particularly striking. So here is the breakdown of professor responses to the question that we just saw, which is, what theory should judges apply when interpreting the Constitution? So the most popular theory here was living constitutionalism, with 70% of participants either accepting or leaning towards that theory. This was followed by common law constitutionalism and pluralism, both of which had over 50% endorsement rate when combining accept and lean towards responses. And you can also see here that originalism is actually nowhere near majority endorsement rate. And in fact, just over 17% of professors endorsed originalism, whereas the vast majority rejected it. And as Kevin mentioned in the introduction, this is a pretty, we found this a pretty striking result given comments, which since have been kind of clarified a bit by Justice Kagan and others, proclaiming that we are all originalists now, which would otherwise kind of give the impression that originalism is somehow this very widely endorsed theory. And also, conversely, given that originalism is seen as mutually exclusive to other forms of constitutional interpretation, this might also otherwise give the impression that these other forms of constitutional interpretation are not so widely endorsed. So yeah, that's one thing. Another one that we found particularly striking relates to statutory interpretation. So this is a breakdown of responses to the question of which theory judges should apply when interpreting laws or statutes. And so, as you can see here, purposivism is the most widely endorsed theory among law professors in our sample. And purposivism is this idea that, at least in general terms, that laws should be interpreted according to their purpose as opposed to their literal text. And it's often contrasted with theories like textualism, which states that laws should be interpreted according to their text, maybe to some degree as opposed to their purpose. But as you can see here, it seems that most professors actually endorse both textualism and purposivism, which sort of goes against this idea of the two being mutually exclusive, and also provides clarity to prior statements that Kevin kind of alluded to, or at least the sort of comments that Kevin alluded to, where people kind of make claims of, say, we're all textualists now, textualism is dead, we're all purposivists now, and so on. And so you can also see from this table that most participants also endorse pragmatism and intentionalism, which underscores kind of a broader theme from the results, which is that law professors seem to adopt a pluralism of views with regard to a particular legal theory, as opposed to endorsing kind of one theory at the expense of another. So yeah, that's that. And then also, another question where you can kind of get a sense of this pluralism is this question about the goals of criminal punishment. So here we asked law professors, what should be the goals of criminal punishment, and overwhelmingly there was an endorsement of rehabilitation as well as deterrence and incapacitation. And interestingly, there was a fairly firm rejection of retribution as a goal of criminal punishment. And this is something that, at least in the United States, you might consider to be kind of striking, that the United States criminal justice system is often perceived to not be pursuing the goals of rehabilitation or deterrence, at least not, as successfully as you might consider ideal. And also on the flip side, given that the U.S. criminal justice system does seem to be pursuing the goal of, retribution, at least is often kind of a perception that some might have. So we also find a strong rejection of the idea that there should be kind of no criminal punishment, which relates to the fourth result that we wanted to highlight, which is law professors' views regarding incarceration as criminal punishment. So on this table, you can kind of get a sense of three pretty interesting takeaways. So the first is this very strong rejection by law professors of the view that we should preserve the incarceration system as is. The second is a basically equally strong endorsement of the view that we should revise or reform the system. And third is a fairly strong rejection of the idea that we should abolish incarceration as a form of criminal punishment. Though this last result is pretty interesting kind of in both directions. So on the one hand, Kevin and I received some emails from professors saying, this result was pretty striking to them because at least in certain subfields of criminal law scholarship, their perception was that prison abolition was the consensus, not the dissensus. But on the other hand, in our paper, we also cite some scholarship referring to prison abolition as this unfathomable legal theory that is seen as a non-starter among legal academics. That's the perception you had. Then this result is actually pretty striking in the opposite direction, because 13% is in a lot of respects actually not a trivial number. So in a footnote in our paper, we kind of present some back of the envelope calculations that suggest that if you assume even a more conservative endorsement rate than this, then you would estimate that the typical US law student is actually more likely than not to have at least one prison abolitionist as their professor during their first year. And so there's kind of multiple ways, I guess, to interpret some of these results in interesting ways. So those are kind of just a few of the results that we kind of found the most striking. I'll just sort of briefly go over the limitations of the study before handing it off to Kevin to discuss kind of the implications and the future direction. So in the paper, we discuss at length 5 different objections you might have to the study's design. And in doing so, we present arguments for why the force of these objections we think is limited. So the first is just sample size. So, do we have enough professors to make meaningful statistical inferences? Here, we argue that we can very confidently say yes. So for example, if you just use a basic sample size formula, such as Cochrane's formula, you'll get something like 300 people as the required sample size to be able to draw inferences with less than a 5% error rate for our population size. And in this study, we got over twice that number at 667. And so, and you can also just test this empirically. If you in the paper, the error rate that we find for our legal theory responses is quite a bit lower than 5%. So yeah, that's the first objection. The second objection is kind of just representativeness. So in other words, did our sample accurately reflect the population of law professors at large with regard to demographic and other factors? This one, we say that the answer to this question is a bit trickier, given that there aren't widely available statistics regarding the demographics of the legal academy. Though, as we do point out in the paper, available estimates seem to indicate a similar breakdown of gender and race as in our current study, given the limited information. At the same time, we also kind of point out that our results were fairly robust to different demographic factors. So in other words, it wasn't just that only conservatives were textualists or that only male faculty rejected originalism. And so even if we weren't confident that the sample was perfectly representative, this wouldn't undermine the general pattern of results to undermine most of the kind of general takeaways. The third objection you might raise here has to do with kind of ambiguity in the question. So if participants didn't actually understand what they were responding to, then we as researchers also wouldn't be able to interpret their responses in a meaningful way. The main response to that is that our design kind of allowed for participants to pretty easily indicate if they found the questions ambiguous or underspecified in some way. So if it were true that the questions were ambiguous, then you might expect that law professors would just respond other to most of the questions. But it turns out that we didn't find this. So across all questions and participants, less than 10% of responses were other responses, indicating that most people perceived the questions to be sufficiently well posed in order to warrant a main response. And the fourth objection you might have is obviousness. So you might think, well, sure, I believe in the results, but this doesn't really tell us anything we didn't know before. And it seems that there are at least kind of 2 straightforward responses to this. So one is that we cite pretty strong and widely circulated claims of consensus and dissensus about certain views regarding different theories, such as, we're all originalists now, we're all textualists now, and sometimes those claims kind of conflicted. And so, and also, in our many cases, our results directly challenge those claims, which suggests that the results are not too obvious. And then the second is that we did try to quantitatively measure the surprisingness of the results by conducting a meta survey in which we asked professors to predict, how they thought other professors would respond to the survey. And it turns out that the typical predicted error rate among meta survey participants was also quite high, which again indicates that, the results aren't too obvious. And then finally, you might just object that participants, aren't being honest. And if participants aren't being honest, then you can't trust their responses. Or, at least the inferences we're drawing from the responses. And so one way to get traction with this objection is to just look at other types of polling and see how well they track the ground truth. So in the case of political polling, it turns out that US presidential polls tend to have an error rate of about 6% in terms of how well they predict actual voting behavior 21 days from an election. And if you assume a similar error rate here, this would give us some pretty good confidence in the robustness of our results, given that most of the legal theories had an endorsement rate that was way more than 6% above or below 50%. Depending on kind of how you, depending on the kind of the inferences that you're trying to make from the results, that's kind of one way to look at it. And then also, there's also several reasons to expect that we would see a smaller error rate here than in political polls, given that, for example, our sample size was larger relative to the overall population than political polls. In addition, our method of data collection was much more anonymous than live call-in polling, and our survey was attempting to capture current beliefs as opposed to future beliefs. And so given all these reasons, it seems like we can be pretty confident that these results hold water empirically. Of course, it's possible. In this short presentation, I kind of give too heavy-handed a treatment to some of them, and if so, feel free to push back in Q&A. But The next question, assuming that they hold water, is what are the implications of these results? And with that, I'll turn it over back to Kevin to discuss those implications.
Yeah, thanks so much, Eric. I mean, and I mentioned we could also discuss implications sort of in the Q&A. So I'll just sort of say a brief word about some of them, and then implications, and also kind of future directions and possibilities for this sort of project. So, I mean, a lot of the implications are kind of straightforward from our setup, right? So, like one kind of primary goal was, as we said, sort of taking stock of legal theory debates. So in debates about constitutional interpretation or statutory interpretation, what are the views that most law professors endorse, and that we could take that as some indication of which views have proven persuasive. I think also, perhaps like the more interesting thing for our purposes, like from some of these results, as Eric already mentioned, we sort of learn new ways to think about these debates. So, right, there's a bit of a false dichotomy, textualism versus proposivism, and so our results suggest that actually a lot of professors, if you think think of them as legal experts, right, legal experts are endorsing a more pluralistic view of interpretation, and so accepting or leaning towards textualism and proposivism simultaneously. Another result sort of along those lines is you might have expected before the study that some of these questions are just inevitably difficult or context dependent, but we had that as an option. And actually in a lot of these debates, participants didn't opt for a sort of radical context sensitivity. They actually reported a more concrete view, either accept, lean towards, against, or reject. So I think to me, like, those are some of the sort of like bigger or maybe like more surprising implications, sort of big picture about the legal theory results, is this kind of plurality, and then also many more professors were willing to sort of volunteer an answer than you might expect if you thought there were a lot of these debates are context dependent or otherwise kind of too difficult to answer and pin down one simple answer. So that's purely descriptive, right? Sort of what views do professors endorse? Depending on your assumptions or views, you might put some more normative weight onto these results. So you might think that, in particular, if you think law professors are legal experts, and legal experts have some authority, or at least the considered view of the consensus of legal experts would give you a reason to favor a particular view, right? You might think that in some of these results, where either the majority or the sort of overwhelming majority of these legal experts are endorsing a view, that gives us a reason in favor of thinking that the view is true, as one that we should hold. So this is obviously like a more controversial interpretation, and so we're sort of careful. We don't want to endorse this kind of across the board, but depending on the particular debate, you might think that these results have that kind of normative weight, giving you some reason to actually that counts in favor of the view. I guess thinking about legal education and the legal academy, the composition of itself, some of those results, right? So the centrality questions: is comparative law currently central to the legal academy? Should it be central? In the same way, right, that gives us some descriptive purchase on what the academy looks like now. And as Eric mentioned, like on big picture, right, a lot of these areas, there were more areas that were quote unquote under central than over central. And so, right, this is, I imagine, something we could talk about here. Assuming that law school won't go on forever, we've got a limited number of courses that students can take, right? It might not be possible, even if we took these results as normative, to sort of successfully give every student every one of these courses. But I think kind of some of the broader trends are again instructive, right? Thinking about moving past kind of anecdotes about which areas should be more central to a sort of bigger and also kind of more quantitative way of looking at that question. We can get a sense of which areas are particularly understood by many participants as under central. So some of those areas like legislation and poverty law and legal drafting. Another implication, again, maybe slightly more kind of or like less straightforward way to think about these results might be to think about that centrality gap as telling us something about the future development of the academy. So if you think that law professors have an influence on the academy and how it will be shaped. Right, you might think that the areas that professors think should be more central will in fact be ones that they will work to make more central. And so if some of these areas where there's a centrality gap, or really any area that has a kind of high normative centrality, people think it should be more central than it is. Again, these are complicated questions. There's a lot of factors at play in terms of how the legal academy will develop, but this is giving us some insight into at least the preferences or the views of professors, and insofar as they have some influence, it could give us a bit of a window into future developments as well. This last point is just very briefly is about more future directions or extensions. And so again, taking a cue from David Bourget and David Chalmers on the philosophy survey, they've now repeated that one a second time. So I think that's an interesting idea for this. So if we've repeated this study in 5 or 10 years, right, you can also then start to get a sense of how both legal theory and the academy are developing over time in America. And then the other possibility would be extending this. And so, in the same way that we took a cue from the philosophy survey, I think it would just be really fascinating to see also extensions with respect to questions that are more relevant either to different disciplines or different legal jurisdictions. So in formulating this list of questions, our questions are very much focused on American legal theory, originalism versus living constitutionalism. And even that, we're pitched at, because we've recruited all law professors independent of their specialty to answer these questions, we're already at a pretty high level of generality, right? So we'll have corporate law specialists answering constitutional law and property law specialists answering corporate law. And so, we sort of found that as a workable approach. But if we included questions that would be relevant, say to Italian law or something, our sample would be less. It would not be the right sample. And so, I guess there's just a long way to say, although our project is very American focused, this set of questions obviously need not be. And so it would also be wonderful to sort of think about extensions in kind of cross-culturally and cross-jurisdictionally. I think we're at about 30, so maybe I'll stop here and kind of pass it back for some comments and questions. Thanks.
Thank you very much, Eric and Kevin. Let me share the screen. I just want to show our audience the article, the excellent piece of research you worked, that you wrote. I read very carefully your paper. I like it very much. I have some formal, substantial comments. But before doing that, just to remind our students, I already told them, look, this effort, this piece of research is very important in the sense that is something that I think not only in the US, but across different regions, law schools must be very concerned about how to design a program of studies that considers, of course, both the interests of academics, the research interests of academics, what you call centrality or non-centrality, that of course takes into account what is versus what ought to be, very important, but something that perhaps we forget or we tend to forget in legal academia, and is that basically we are, or at least that's my point of view, we are here for the students. How can students gain as much as possible from their experience, either at an undergraduate level or at the graduate level? In Colombia, law is an undergraduate program. And of course, I guess that will have to be for many years to come. I guess we haven't reached that point where we can offer law as a graduate program, but perhaps we can think not only about the duration of the program, but about the centrality of the courses that we offer. Of course, as Kevin said, this is the perspective from professors in the United States. Correct me, but perhaps another part of the research, future research, not only by Kevin and Eric, but by other academics is, okay, how we balance this with what students expect from a law program. We can discuss that. But let me first congratulate you for this excellent piece of research. Basically, I want to comment on something that I am very worried about in terms of legal academia, how we, both professors and students in Colombia, conduct research, and how do we write. I think proper legal writing is key. And I think we are evolving. I saw in one part of your paper that I guess back, the idea of professors writing law papers, legal papers, is dates back to the 60s, perhaps in the US. I mean, like, it is expected from professors to write. So when I see this, I see many virtues. On the one hand, well, you have a 70-page paper. Let me show our students as to the formal aspects. Yeah, so you have, one second, you have like a 70-page paper, basically, about, one second, about 370 footnotes. Well, each and one of the paragraphs is clear. One of the most difficult things is, for me, and I guess for every academic, is, okay, try to convey clarity for the layman, for someone who doesn't know, but he can understand, you know, what we are writing. So I guess you achieved that. Of course, perfect structure of the paragraphs, perfect grammar. I guess Kevin is familiarized with this. In philosophy, both professors and students tend to be very, very picky about the accuracy of words, about how we convey ideas. So I find that this paper is, of course, outstanding. That's as to the formal aspects. Of course, the effort of research, the survey, the way you conducted this service. I guess you had two groups of law schools, one like at the 51st law schools, and then you collected this information. I'm not so sure, but in Colombia, at least in the legal academia, and we can learn from you a lot, we do not tend, although we are improving, or we are making efforts in that regard, we don't tend to rely too much, although, of course, there are academics who do that, on presenting statistical results, perhaps because we haven't been trained that way. But it's key. And perhaps, for example, in my case, I should learn that. Okay, that as to the formal aspects. I show this paper to my students. I don't know if in the future I can share this draft or only until it's published, but I would like to share this with my students, in part because I want them to see how a good paper is structured, how you build each and every one of the chapters, how you present the main working hypothesis, which is key. Okay, that as to the formal aspects. I think it's worth noting, when one of the things that Eric mentioned, and of course Kevin as well, well, the centrality or non-centrality, I think this is key for any law school to conduct a successful review of the program of studies. One other thing that Kevin mentioned, which is, of course, there seems to be a focus on for example, how the Constitution, the schools of thought about interpretation of the Constitution. I found this very relevant, not only in the US, but in Colombia. Well, we're seeing what is happening in the US. We are seeing this thing about the 14th Amendment and the efforts to impede Trump from running again. And well, scholars such as Tribe, for example, Lawrence Tribe, well, he has this interpretation. So this is, of course, this has an importance from the academic point of view, but what I want students to be aware of is that it's academic, but this affects the human daily lives of people. I mean, when we talk about how to interpret the Constitution, whether you are an originalist or you are part of the living Constitution school or textualist, or, well, the other school that I didn't know about, the purposivism, for example. This is key. And this is something that perhaps in Colombia, the Constitutional Court, they don't call this originalism or living, but in the hermeneutic process, magistrates and judges are doing that. Students are doing that whenever they read a piece of jurisprudence, whenever they read a piece of legislation. So this is key. You mentioned incarceration. Let me tell you one thing. In Colombia, we have a president who thinks that excessive incarceration is the wrong way to go. So, okay, on what basis? What are the studies? What are law schools doing to support those views? A third issue dealing with the substance of the article, which I like very much. At one point, you say, okay, on the one hand, we have the limitation about how representative the sample was. On the other hand, the obviousness. I'm training philosophy, and I like a thought about one of the thinkers that I like the most. He says something, in order to measure your own, excuse me for using this word, your own degree of stupidity, ask yourself what is obvious to you. How many things are obvious? Nothing is obvious. And that should be the premise. That should be the premise, or one of the premises, I guess. So I like this very much. How we question, how we take a second and ask, okay, is this so? Is this what we should be doing? Is this what is being done? So if you allow me, I would like to share the paper with the students. Yesterday and the day before yesterday, I told them, look, we are going to have two outstanding academics. They wrote this piece, excellent from the formal point of view, from the substantive point of view. Please be aware, you are actors. It's not only the professors. Okay, this is from the perspective of professors, but you have a say. You should have a say as to what the program of studies must be like. So thank you very much. Thank you. To me, this is a role model in terms of how to write. We in Colombia, of course, are in the process. Drafting, preparing articles is somewhat new in the context of legal academia in Colombia. I mean, somewhat new is from the 90s on, which is, compared to the US, new. I mean, it is expected from us to publish in law reviews, not only Colombian law reviews, but hopefully in US law reviews, European law reviews. So that's part of our work. And part of what we expect students to learn is to write pieces like this. In that sense, and based on our schedule, I would like to start sort of a dialogue with both Eric and Kevin. I have some questions. Antonia is writing. There are some students. There will be a space of time for them to ask the questions. I have one question directly related to the paper, which is here for the audience to read. Does the fact that faculty tends in your study not representative of the general population have a negative influence on the quality of legal education students receive?
After those comments, I just have to say very briefly, thank you. That was extremely generous, and lots and lots of credit to the paper's first author, Eric, and also to the so we're publishing this paper with the Georgetown Law Journal, so also lots of credit, I think, especially on the footnotes to the Georgetown Law Journal editors. There's a lot of students who were enormously thoughtful in the editing process. So this question you just proposed, I think, is really rich and interesting. I mean, I think also quite difficult. I mean, so one thing to say about faculty, is the faculty representative of the general population, and does that have an impact on education? And so, I mean, just as like one sort of preliminary point, I think in line with your kind of philosophical way of thinking, which I share, right? So I think the answer depends, right, on the dimension of representation. So just as like a sort of easy example, most of the general population does not have legal training, like no law background, no legal expertise. But we probably all agree it's very good that law faculty are unrepresentative in that respect. That is, law faculty have legal expertise, even though the population doesn't. So that's a great feature that law faculty have that improves legal education, despite being unrepresentative. So it's sort of a silly example in some sense, but I think it illustrates the broader point, which is, right, the answer really depends on what kind of specific feature we're discussing. And I mean, I think kind of once we move to more controversial examples, people may have more disagreement, but I mean, just to put, one on the table, I guess other considerations about this question, right, is what feature of the general population are we thinking about as represented? Why is that feature underrepresented? And what relationship might that feature have to legal education? So if you think, there's a lot of discussions in the US, I'd be curious to know about in Colombia as well, about like representative with respect to, say, gender, right? So if you think about the why question there, right? Like at Georgetown, it was just over 70 years ago that the first woman was enrolled at Georgetown Law. And so in some sense, recent history, right, the legal profession in America was off limits to women and minority groups. And so that's a particular story about unrepresentativeness in the legal profession. And there's still important barriers to entry and gender and racial disparities at all levels after law school, right? Law professors, law firm partners, judges, right? And so, that's an example where we think about like that particular history and representation and what it means to live in a diverse and pluralistic society. And I think, right, your answer there is very different to your answer to the question of whether law professors should be unrepresentative in their legal expertise. As we go down the line, right, there's going to be more controversial examples, and I think it's tricky in the context of our study. I mean, I think one more to put on the table that maybe speaking for myself, I guess I have a different answer to. So if you think about our legal theory results, right, so we now have a sense of what views our sample of law professors hold. So, what would it mean to have a representative number of purposivists on your faculty? Is it important that law school have a representative number of purposivists or living constitutionalists or whatever theory? I think many people think no, right? And the thought there is that with respect to legal theories, sort of the part of the virtue of being a thoughtful professor is, if there's a theory that's influential and sort of objectively worth teaching, even if you don't subscribe to it, you can nevertheless consider it, evaluate it, its strengths and weaknesses. And to some extent, that's a skill, right, that we teach to students, right? Whether or not you subscribe to this view, whether or not the judge before whom you're arguing shares the interpretive theory that you do, can you speak that language and make a persuasive argument? So I think that might be an example where, and again, at least speaking for myself, representation, with respect to, proposivism or something like this might be we might have a different answer. So sorry, I apologize for the very long answer, but I think Andres, it's such a rich question to start us out with. Yeah.
Perfectly clear. Thank you very much. I don't know if Eric wants to comment on that or.
No, those are incredibly nuanced thoughts, and I
Okay.
I don't think I'll have.
Okay. Perfect. I have a question that, well, your article was very thought-provoking, so I would like to hear your perspective. Can we achieve a balance between our interests as academics, as professors, the current program of studies, and what the legal market need or seem to need? Perhaps this is simplistic, but I think it's somewhat clear. Theory, fundamentals of law, philosophy of law, etc., versus practical training. Okay, the law school in Colombia didn't teach me how to draft a contract. I don't need too much study about natural law or positive law, but I need to survive in the legal market. Okay, how do I negotiate an agreement? How do I draft a clause? How do I draft a paper like yours? Is it realistic? Can that be done, in your opinion?
Eric, I have some thoughts, but if you want to, do you want to start or?
No, you can go ahead. I'll maybe add a few things at the end. But
yeah, that sounds good. Okay. I mean, so yeah, these are such great questions. They're like really like wonderfully big picture and important, right? So thanks for kind of pressing us on the important questions. So, I think part of our goal in the paper, right, is like I think these questions. What should the curriculum look like? What should the balance be between practical and theory? Training to draft a contract, training to draft a law review article. Those conversations are happening at lots of law schools. And so, like the sort of simplest thing that our study is attempting to do is just to add to those sort of ad hoc one-off anecdotes with just a picture of what the kind of broader, this broader sample says with respect to those questions. So, if we take that at face value, which I think, if you're kind of inclined to take one-off anecdotes at face value, then I think the survey results are helpful. Our study suggests that there's a bunch of different areas that could be more central. And so if we really leaned heavily into the centrality gap result, that's actually consistent with a lot of anecdotes, right? So like these areas, so there's a lot of emphasis. I think recently, many law schools have begun requiring, over the past 10, actually 20 years, have been requiring legislation. Not all law schools, but more law schools are requiring legislation and regulation, or some sort of class that's dealing with statutory law. Like the American 1L curriculum often focuses heavily on common law subjects, common law, contract, tort. And so that you see that reflected in our survey results. So a lot of participants treated legislation as an area that is not currently as central as it should be. And so, but there's a whole bunch of other areas. Legal drafting is another, practical area that the centrality gap was pretty big, that, participants were saying legal drafting should be more central than it ought to. And then a whole bunch of other areas, poverty law, energy law. And so, again, I think what our study is contributing is just a picture of this kind of broader perspective from like a very large sample of professors, rather than just, one or two in the hallway, right? So to sort of fill in with that. Of course, I think, just as you emphasized, we're studying professors, but there's other people whose interests might be relevant here, like students or practitioners. So, what on the practitioner side, right? Like, what do law firms look for, or what do legal employers look for, right? That's a very different sort of question from what we're asking. We're focused on the law professor responses, but there's other research in the American context. So there's this like Lexis survey of law firm senior associates and hiring partners, and they ask, what skills are most important. And actually, some of those results are consistent with the results from our study. So, to kind of get back, to take the example of legislation again, like the idea that legislation should be more central, that comes out in that hiring partner study. They find hiring partners and senior associates report that proficiency with statutes is very important. So that's a sort of convergent answer there. And then, but there's also more we learn from that. So hiring partners reported wanting stronger litigation, writing, and drafting skills, for instance. So, part of what makes this question complicated is the potential. There's potential for mismatch. So maybe what law professors think is most critical, what legal employers think is most critical, and what students think is most critical doesn't perfectly overlap. And that would be a difficult question for us to resolve. But I think the first step is, let's get some data right about what these different populations do think is kind of critical and important. And once we have the facts, that'll enable us to have a richer conversation. There's a long answer about this. One last tiny point is, I think the sort of theory versus practice question, should we be teaching legal philosophy or practical skills like contract drafting? I think it's a really important and recurring sort of theme in these discussions. But at least in some contexts, I don't think it's an either or, right? So if you take contract drafting and contract interpretation. So Schwartz and Scott have this article where they claim that most contract disputes in America involve contract interpretation. There's a lot of contract classes that won't teach interpretation at all. So they'll talk about contract formation and other contract doctrines, but there's actually not much emphasis on interpretation. But it might be that there's a lot of rich legal theory actually about contract interpretation. And so kind of adding some discussion of contract interpretation and drafting could serve two purposes, right? Kind of tooling students up in some contract drafting skills, while also welcoming some legal theory. And so I don't think I want to put too much there's not a magical answer, right? It's not that theory and practice will always kind of work like this perfectly, but at least in some contexts, it might be the case that in some very traditional areas like contract law, which was, an important part of the first year curriculum, there might be some additions or modifications which score well on both the sort of theoretical and practical goals.
Mm-hmm. Yeah. And I would add, okay, maybe this is a misnomer, practical versus theory. One could say, okay, why should I study aspects of philosophy of law? I would say, okay, this is practical. This is very important. So it's not easy. I understand it's not easy. Thank you very much, Kevin. In your opinion, as I told you, we are reviewing our program of studies. We're in the process of restating or changing how we teach law here at Javeriana. What is the ideal law school, in your opinion? How it should look like today?
So this is a question where, again, right, different folks will disagree, I guess, but you're asking me, so I'll give you some thoughts. I mean, you've heard a little bit about the view already in the last answer. So I think my own personal views fit with actually some of the results from this survey. So I think this emphasis on interpretation and drafting, I think that's actually quite useful. So, even when I teach tort law, my tort law class features a bit more statutes and statutory law than a pure common law class. I don't mean to be dogmatic about this, right? I think different classes can adopt different approaches, and so there's also just a great value to pluralism. But I think the sort of broader answer with our paper is that our main interest is just contributing data to these discussions, right? So it could have been that there's actually no general tendency to see any area as especially under central or over central, right? That's a possible result we could have had. I think it's pretty interesting that that's not the case, right? It's not that, people sort of say, every area, kind of like radical pluralism, every area is kind of perfectly central, kind of as it is or something. So if you are to take, put some stock in these results in terms of a sort of recommendation for what the curriculum ought to look like, it's useful in that sense, right? That there is there are lessons to be drawn about which areas are seen by our sample as relatively most under central. It's sort of along that vein, right? Ours is not the only empirical study, and so I think my main recommendation would be in kind of having these conversations, just thinking kind of moving past anecdotes, but also trying to analyze this with some data. So there's a nice paper by David Hyman, Liu, and Teitelbaum. So these are two professors. This is a bit of a Georgetown plug. They are professors at Georgetown, but they've done a study because the first year curriculum here, it's a very large law school. There's about 600 law students a year that enter. And so one of the classes, about 100 students, participates in an alternative curriculum. They elect to be in this. It's colloquially called Curriculum B or Section 3. And so it has all of the typical content that you would have in a normal law curriculum, contract tort, but it's also more focused on theory and in some way focused on questions about legal justice. And so what these folks did, these professors, is they studied, does the assignment into that section affect students? Does it have an impact compared to the regular curriculum? And they find some interesting differences. So like the students who take that course, they end up choosing different classes when they're in their second and third years. And so I think just as a sort of illustration, this is a paper that's on SSRN. So if you search for David Hyman and Josh Teitelbaum, this paper is available. And I think there's just another nice example where there's just a lot we can learn, right, by studying legal education empirically. And so that's a long way to say the choice of courses in the first year also seems to matter, right? You might think, it's not a big deal as long as our students get the same legal skills, whatever course they take. But it seems like the courses do make some difference. So again, I think so our sort of main recommendation in line with the thrust of the paper is just to get some more data and some more evidence about all of these questions.
An evidence-based approach.
An evidence-based approach, yeah, a bit. Or supplementing the discussions with evidence. It doesn't have to be sort of like purely data-driven or something like this, but I think just adding, that's the contribution we're trying to make to the discussion anyway.
Excellent. Well, thank you very much. I have other questions, but let me summarize because I wanna have the chance to address the questions that students are asking. I don't want to be the sole person who asked, perhaps Eric. In 2011, I was a visiting researcher at Georgetown, and I discovered this, which was very interesting. By the way, when I invited you, then I Googled this, and then I discovered another paper from I don't know what professor who wrote, no, there is nothing like this in any paper. Okay, so let me cite Chief Justice John Roberts. He said, pick up a copy of any law review that you see. The first article is likely to be, the influence of Kant on evidentiary approaches in 18th century Bulgaria or something, which I'm sure was of great interest to the academic that wrote it, but isn't of much help to the bar. Is this valid? Of course, we have in Colombia and perhaps in the US this problem. I remember an editor here at the editors in Colombia must be professors. That's perhaps something that we should change. I don't know. And he told me, look, your article was accepted. This is congratulations, whatever. But we all know that these articles, no one reads these articles, okay? So, okay, congratulations, bye-bye. I asked my students, look, do you find the articles useful? Is this true? What does proper legal writing mean? I discovered an opinion from Eric, which I share. I hope that I understood it correctly, having to do with complexity. And well, of course, we must be complex, but complex is not equivalent to obscurity. I don't know, perhaps Kevin knows about, well, when one reads, for example, German philosophy, there's a story, I don't know if that's true or not, that some German philosophers, Hegel, not Schopenhauer, Hegel, for example, or other, they thought, okay, the more obscure I write, the more I will be appreciated by people, no? If people do not understand what I'm writing, oh no, they want to say, I'm so intelligent, but I'm not so sure about that. Well, at least in the legal field. So What do you opine about this? I think legal writing is key. And let me link this question with skills. Do you think, excuse me for asking this question, but we are having this debate in Colombia. Should we teach students how to properly write? Is it possible to teach students how to properly write? And for us academics who like to write lots and lots and lots, what do you think about this?
Sure. I mean, I guess Kevin can speak more to the second point as a current law professor, but I guess to the first question here, I mean, yeah, thanks by the way for plugging the article. I guess, yeah, I've done some stuff on legal writing. There's obviously multiple forms of writing, but it doesn't work on the form of legal writing with Ted Gibson, who's my advisor and colleague at MIT, along with Frank Mollica, who's a computational cognitive scientist at Edinburgh. And I guess one takeaway from that work is that, first, legal writing is often unnecessarily complex. Second, can often be simplified without a loss or distortion of meaning. And third, that, even practicing lawyers actually prefer legal documents to be written in a simple manner. Those are kind of, maybe simplified takeaways, but I guess just to expand on that a little bit, I mean, in terms of like complexity, it seems like legal writing is difficult to understand compared to other texts, even academic texts in the realm of syntax. So for example, it seems like, a lot of fields have jargon. Legal texts seem to have a lot of jargon. But what seems to separate legal text from other texts is like these complex syntactic instructions that are often referred to by linguists as center-embedded clauses, which tend to separate words that depend on each other from each other in a sentence. And this basically tends to, impose a superhuman constraint on working memory capacity, which makes it very difficult to retain anything when reading a legal text. And I mean, in some sense, people kind of know this, that like lay people often, there's kind of been an observation for a while, the lay people tend to not be able to read or want to read legal text, but it turns out that it's also true for lawyers, that, lawyers actually struggle to understand legal text when they have a lot of these, center-embedded clauses and complex jargon, relative to when they have simple syntax and more frequent vocabulary. And I think, this relates to it. I think what you were just saying, Andrés, that it's not just the case that lawyers struggle to understand these texts, but also they tend to prefer legal texts that are written simpler relative to texts that are written in a complex manner. And so, I guess one takeaway there is just, I mean, complexity is important. That doesn't necessarily mean, obscurity, like you said. And I think this, to some degree, dovetails nicely with our results, as law professors seem to think legal writing is a skill that's currently being underserved in the academy, and perhaps the norms around legal writing could be improved with a greater emphasis on these skills, to the extent that you can teach them, which I guess was another part of your question. I mean, that's the form of legal writing. I guess embedded within this question is kind of like, content of legal writing. I guess, Robert's opinion was talking about, like the content of those articles was a bit obscure in some way. And I don't have as much to say about that, other than, our results do seem to suggest that law professors might actually agree with Robert's high level take that not all law review articles are suitable for, for whatever purposes they should be serving. But maybe not Robert's low level take that the issue is most related to, like, Bulgarian history. And in fact, maybe they might even think too many articles are geared towards, aiming to be read by John Roberts or something. But yeah, I guess those are some thoughts. I don't know.
I would say that there is an hermeneutic problem, in the sense of, just as we mentioned, theory versus practice. Okay, what is theory and what is practice? What is clarity and what is obscurity? Yes, perhaps in the view of John Roberts, this is useless, but who knows? Who knows? And the fact, which is another problem in Latin America, global South, we are facing is, okay, we see professors like Kevin and Eric, widely cited, super recognized scholars. That's very nice. You publish in the most important law reviews, but what happens with academics from Latin America who do not have access always to these top law journals? Okay, what I'm saying is, perhaps this academic is not widely cited. Perhaps he wrote about something that not many people are interested in, but that doesn't mean that that piece of research isn't has value. So we live in this. I want to give the floor to Antonia. Perhaps you want to appear in screen. Just read one of the questions your classmates are asking, perhaps not all, but I will pass them on to Kevin and Eric. We have through 3:40 approximately, unless you have time, and we can extend and answer as many as possible of the question, as many as possible that our classmates, students ask. So go on, Antonia. Thank you.
Perfect, Andrés. Thank you very much. And me and my colleagues are really honored to be in this panel today. And we had the opportunity to formulate some questions. So the first one is, in Colombia, in law schools, the dynamic between students and professors is a vertical relation of power. Do you believe that if the survey studied the same questions but directed to the students, the results will be different to the initial survey? And if so, wouldn't it show that there is a greater influence from students in the academy rather than professors' influence?
That's a terrific question. So the short answer is yes, it would be wonderful for someone to conduct that study. I would love to see the results from students. I think also the results from students over the course of their law school career. So when students start, what do they kind of hope to get out of their legal education? What do they expect from it? And then as this power dynamic kind of emerges, what and also the legal education begins to happen, right? How do those views change? So just from the sort of empirical legal research side, I think there's a wealth of underexplored questions about like that kind of legal development, sort of like what and there's a lot of nice studies that one could do there. So this is a way to say I really appreciate the question. I think it would be an interesting survey to run, and then what to take from it. What significance does it have? I think I share. I don't know if Antonio, are you the questioner, or is it someone else's question?
This is my question, but the colleagues, yes.
Yeah. So okay. So I don't know. So I think I share your view that it's not the students' view is very important. Is a way to put it. It's this. I was thinking it's sort of a complex relation in terms of if we're having the discussion, how should the academy or how should legal education evolve? The answer is not located simply in the views of law professors, as our paper might suggest. So I think that I very much share that view. And so, I guess related to Andrés' previous question, what skills should we be teaching? If the students are demanding different skills, I think that's highly relevant. Often my students are very concerned about their, what am I going to do after law school? And so, skills, that might be a reason to think about these studies about the law firms and the employers and what skills they want, and thinking about the match between those desired skills and student skills. Like one other, I guess, like asterisk on this is I suppose like one other skill that I think is important to instill in students, to get to Andrés's question. I imagine students might share this view, although kind of beyond learning legal doctrine and learning law, developing critical thinking skills. I think, another goal is to really empower students. So this is why I'm talking about the mixture between student and professor. So empowering students to effectively achieve what they want with the law. So to effectively bring about justice, improve the lives of others, and thinking about what are the tools that as professors and as a law school you can give students to do this. And so for me, I think one of the helpful things, this is, a bit of the pitch for philosophy and ethics. I think legal ethics is very important for this reason, and also training in humanities and critical thinking. In addition to learning the law, it's very important during the legal education to make space to criticize the law, and also to think critically about what you'll do with the law as you transition from that student on day one to legal actor with lots of power at the end. And so I think this is a very important aspect of the legal education as well.
Definitely, I couldn't agree more. And Eric, I wanted to ask you this question of Camila, my colleague, because of your experience at MIT. So important historical events have allowed law to evolve, and currently we're living in this technological era where we are implementing technologies such as artificial intelligence into our daily life. So how would you think that the legal academy and the law could face this new challenge?
Yeah, that's a great question. I honestly, I'm not quite sure what the answer is. I think things are moving really, really quickly, and I think hopefully we can find out the answer in time to make good changes. I mean, yeah, I think in the last few months there's just been an explosion of like really, really important papers showing the capabilities of large language models like ChatGPT and GPT-4, and how well they're completing legal tasks and achieving, at least on United States exams, achieving like like human level or better than human level performance. But at the same time, it seems like we're still kind of working out what's kind of the best way to like integrate that into I guess legal education and law practice. Kevin can speak more to I guess how it's already happening in law schools. I know there was a study recently by I think Jonathan Choi and Daniel Schwartz showing that like, okay, what happens when you like give law students access to ChatGPT, and how does that affect their performance? And it seems like, I don't know, it's kind of interesting result where it's like if students who are like struggling without AI tend to like get better with AI, and then students who are like kind of at the the right tail of the distribution or kind of at the top are actually like their performance kind of goes down in some sense, which is kind of interesting. I feel like it's not exactly what I would have expected. With other technologies, it's kind of like you might see like a rich get richer effect where people who are already good at something might get even better with technology. And so I don't know. I think it's I'm sure there's going to be, I mean, I think it's definitely going to be important for people to be very familiar with these models. I'll admit that I use I use like ChatGPT very, very regularly. Like, I mean, like for programming tasks is really, really good, and also for certain types of legal tasks. I mean, obviously, like I think you have to be very careful with using ChatGPT. There was an article in the New York Times a few months ago about a lawyer getting in trouble for using ChatGPT and ChatGPT just making up cases. So I don't know. That's not really answering your question at all, actually. But hopefully, these are some thoughts that I guess will, I don't know, influence the. Yeah, I mean, I think there are important considerations, and hopefully there's steps that the legal academy can take to integrate AI in legal practice that would be beneficial for future lawyers, future clients, and and the academy itself. I don't know if you have any additional thoughts, Kevin.
I see there's more questions, so I do have thoughts. If we have time, maybe I'll say a little more, but there are a bunch of other questions maybe we should get to as well.
Yeah, I agree. So the next question is, how would you modernize law studies? And I think that these faces to the idea that, for example, in Javeriana, we have one whole year of Roman law, right? And I personally actually really have like a fascination on the Roman Empire, so I really like it. But I do know that some of my colleagues would disagree on having these like really long class in a modern world. So what are your thoughts on these?
It's a fascinating question, kind of in conjunction with the question you just asked about law and technology, right? And so, I think like one of the lessons from our study, if you look at the list of areas that are quote unquote under central, people say they should be more central than they are. It's a really long list. And so I think like one kind of practical takeaway, right, is we can't have students take all of those areas. There's just not enough credit hours in the day and semesters in the year. And so I think inevitably, right, there's going to be a degree of specialization that happens. And I think that's actually wonderful, right? So, I think like the thought I would add on, and I think it was implicit, I think Eric's answer was terrific, and implicit his answer is we need people, law students like you, who learn about law and technology, large language models, and learn about law and are well-placed to contribute to emerging issues in privacy law, copyright, like basically every legal area is going to be impacted by law and AI. And so, right, we need specialists in those areas. And I think, it's sort of a pluralistic, kind of happy answer, but I also believe it, right? So like, I mean, with respect to any legal area, right, it's important to have specialists. And so this is the sort of trade-off in legal education, right? We need a sort of basic core curriculum. And so there's kind of a question about like, what is part of that? And then also the ability for students to pursue specialization in various areas that will be impactful. And so I think law and technology or law and AI is definitely a really, really important one. Yeah.
Thank you, Kevin. So the next question would be, what challenges are researchers confronted with when adapting the research design from any other social science research paper to a legal research paper, taking into account that your study was adapted from philosophy studies, and what are your recommendations to successfully do so?
Sure, I can say a few things about that. I mean, I don't know. In our case, it seemed, we talked a little bit about this in the paper. Like the main thing was just kind of somewhat low-level details about the question design. Like, we had two forms of centrality, like normative and descriptive, whereas in the philosophy version, there was only one version of that. Because, people, we thought maybe lawyers might be a bit nitpicky about, or like there might be some confusion about what centrality means. That's one thing. And then with the legal theory side, instead of just like, I think in the original Chalmers and Berger study, they just asked like, basically you either accept or lean towards one specific theory as opposed to kind of rating each one individually. And that was kind of one thing that we opted for, because again, there might be a pluralism of views, and it turns out that there was in our study. I don't know if in broad strokes you can really say kind of what the considerations are, other than I think it's really important to adapt like research from other social science disciplines, and I think it's worth the effort to do that, even if there's some sort of like startup costs of learning the differences.
Okay, so the next question would be, in Javeriana, we believe that to be good lawyers, we should be experts in the history of our country. What are your opinions regarding this? Would you say this is a central area as well in the States?
Quick thought on this. I mean, I think absolutely, right? So I'm very sympathetic to your love of Roman law and I think history more generally. I mean, just to make this abstract more concrete, I mean, I'm thinking of one example from a workshop here I went to recently. So one of my colleagues, Janelle George, has written this really wonderful new paper called Deny, Defund, and Divert. And it's an argument about current education policy and a lot of the challenges that are facing Black children in the States in current education policy. And the argument is that when you look at history, if you look at the history of Jim Crow laws, Black Code, slave laws, a lot of the similar tactics that you look in history are being operationalized today. So I just think it's one of many examples we could look at, but in law, there's always a lot to learn from history, even on the most pressing kind of current social issues. And so, I think that this is just one example, but it's a paper that really nicely connects sort of strategies that are being employed today and then the certain tactics that are operationalized. It's just a direct line to tactics that are from history, and by looking at the history, we understand better what's happening today. And I'm very sympathetic to that perspective. Yeah.
Okay, so like changing subjects more to the publishing area, some students wanted to ask, how do you describe the current publishing culture in law journals? Are there excessive pressures to publish? How do you think legal education should evolve to adapt to these like technologies based on publishing?
You want to take that, Kevin? You have more experience with the legal.
Yeah, it's interesting. This one's sort of stumping me. I mean, it's So, you know, I guess, sorry, Antonia, is the main question sort of about like, could you just summarize the question one more time for me?
Yes, basically is how would you describe the challenges that we as students face when we want to publish in law journals? And if you think that technology is like a tool that could help us, or more a barrier for us to like have a better grammar and like redaction strategies.
Yeah, it's a good question. So I mean, there's kind of like a practical side of this question, like how to publish in a law journal or something. But I suppose that for purposes here, maybe I'll address it from a different angle, which is sort of the one that Andrés raised earlier, which is, you know, what does it mean to write a good article? And so I very much agree with what he said. So I think, to me, clear thinking leads to clear writing. And so you know, when I have students who write papers, I'm very much a fan of kind of, if you can explain your ideas simply, that's the kind of the key starting point. And so, right, outlining your idea and understanding the structure, kind of, you know, part 1, part 2, point 3, and then kind of building out from there. So this is sort of simple advice, but I think in a way, this is something that one of my mentors, sort of academic mentors, taught me a long time ago, which is, you know, if you could explain it simply, then you'll be able to explain it well once you kind of flesh it out. And so I think it's a small piece of advice, but it's one that I find useful actually almost any time I'm writing something. And the second is, with academic writing, to me, one of the most important parts is asking a good question. So finding a question, and you can test it out with your friends or something, right? If you pose a question and friends and colleagues seem interested, that's a great place to start. So kind of landing on a topic that generates that sort of interest. Once you have a good question, then you're sort of off to a good start.
Definitely, Kevin. And one last question. We have like a dozen more questions, but we will choose one of the main questions that my colleagues and I wrote in order to have a final session of this panel. So the last question would be, at Javeriana, since law is a bachelor's program, many students double major with other programs, such as international relations, political science, communications, economics, and so forth. Does that enrich the legal scholarship and debates within, or are we at risk of creating lawyers with like scattered minds?
Eric, I have thoughts, but do you want to weigh in at all? Or
yeah. I mean, I'd really be interested to hear your thoughts. I'm happy to weigh in also. I mean, I imagine we're both biased in this regard. I am, you know, I think it enriches legal scholarship. I mean, I feel like the direction kind of goes both ways. I feel like, you know, right now I'm based at a cognitive science department, and I feel like the legal education really enriches the scholarship there. Like I feel like a lot of the questions that I'm interested in, like, were questions I had as a law student, and now it's like, oh, okay, I'll use methods from cognitive science to help answer, and then also from you know, vice versa. It's like, you know, I didn't, without the, you know, cognitive science training, there's so many like really interesting legal questions that that I just would, you know, I guess just be wondering a lot without really having any sort of like tool formally to evaluate it. And, you know, to some degree, like that's kind of the case with this project here. It was like, you know, that was informed by, you know, philosophy, and also by just, you know, I guess training and the different disciplines. So that's one thing. Yeah. Other thoughts, but I'd like to, I don't know if you have any brief thoughts, Kevin, or if we have time to.
Yeah, very briefly. I mean, I think as you say, maybe we're biased. We both have a somewhat interdisciplinary background and sort of approach. But so the short answer is yes. You know, I think this is helpful. You know, a different way to put it is, if you think about law, right? I mean, it's such a enormous field, right? Law is integrated with all of our lives in so many different and impactful ways, right? It presents multifaceted problems. And so to some extent, it's unsurprising that inquiry from lots of different directions, from political science, from economics, from linguistics, from feminism, right? All of these different approaches will help us understand this extremely complex social phenomenon, right? So when you kind of think about it that way, I think the interdisciplinarity makes a lot of sense. in terms of writing, if you're writing especially academic scholarship, like an article for a journal, one of the benefits of interdisciplinarity is it also helps, it gives you a perspective, right? And so you sort of approach a problem from a particular direction, and it can in some way break down this very complicated problem into sort of one dimension that for the moment you contribute to. And so even with our project, right, it's sort of one dimension of the problem. It's not everything, it's sort of a piece. And so, yeah, I think, that's, if you think about fields of scholarship and then kind of law generally, right, it's kind of putting together all of these different approaches, and then we start to sort of understand law by putting them all together. And so if each of us has a little bit of a scattered mind, as you say, like hopefully when we put it all together, we kind of form one more comprehensive vision. And that's the sort of aspiration anyway. But it's an excellent question and nice one to end on. So thank you, Antonia.
No, thank you.
Thank you very much, Antonia. I'm impressed. Well, one of the things about academia is that one learns from students every single day. One wonders who learns more from whom. So thank you very much, Antonia. Thank you very much, the students, Kevin and Eric. I just want to finish, of course, by thanking you. I think it was a very enlightening academic experience. Hopefully in the near future, we can have you in person. Of course, it's nicer to have people in person, but perhaps you can visit Eric, Bogota once again. I don't know, perhaps Kevin doesn't know Bogota, but in the past, we've had outstanding professors from Georgetown and from other universities. We are somewhat close with the Institute of International Economic Law. Chris Brummer is the head of that institute. He has been twice here at the law school. Hopefully, Kevin, not only because the links, the ties between Georgetown and Javeriana, and Eric as well, but because of your research interest, it will be great to have you here. Perhaps in the near future, we can invite you and have you in person. I just want to share two thoughts. I like philosophy a lot, and perhaps this could be useful. Let me share the screen. When I read your paper, two things came to my mind. One is a thought from Seneca. He says, our words should aim not to please, but to help. I think that's key. And I can confirm that this is Seneca. It's Seneca who wrote this. And Plato in the Laws, and this is key in terms of legal education, legal profession. We have to be aware that laws are not have a relatively powerful. I mean, they are not capable of covering every segment of life. So we shouldn't think that the law solves everything. He says in the Laws, there are all kinds of things we shall be leaving out when he talks about legislation. So thank you very much. To me, this was very interesting. I want to thank Antonia for her coordination, Lina, who is here, Andrés Felipe, our head of the department, Professor Uribe. He's the person behind this initiative. My philosophy, Kevin and Eric, excuse me for repeating this, is that the students must run the show. We should be at the law school the ones following their commands, not the other way around. Thank you very much to all who were able to view this event via YouTube. This will be recorded. I hopefully soon will be sending you the link so you can have it on your files. And thank you very much. Perhaps we can say goodbye to all, and then we can stay here for a few minutes and say goodbye between us. Thank you very much.
Thank you again. Thanks to Antonia. Thanks to everyone for the questions. I really enjoyed this. So yeah, thanks again, Andres.
Thank you very much.
Likewise. Thank you so much.